Okay, I believe that we are live. Just wanted to say thank you to everyone who has taken the time to join here this afternoon. Um, Definitely a lot going on in the immigration world over the past couple days. No doubt about that. Hold on one second for me. Okay, so the H1B guy here, and today is another episode of the H1B Guy Live, Unedited Unscripted Q&A Part 4. Today we have a lot to talk about. We have the H1B interim final rule that was released yesterday by the DHS and DOL on behalf of USCIS. We still have the October visa bulletin to talk about. And then we still have Senate Bill S386 to talk about. But before we get started, if you're watching this video, I'd just like to ask you to like it, to subscribe to the H1B Guy channel here on YouTube. Just really appreciate that. If you already are a subscriber, we're almost to 300 subs. I'm just so humbled by that. Just really appreciate it. I also wanted to mention that if I can help you and advise you based on your current case, assist you in your case management, please reach out to me. I'd love to hear how I can help you. I'm definitely working on a couple of other things, my town hall type session that we should be announcing in a week or two. But just really excited today to talk about news and what's been going on. Um, so without further ado, let's just get right into the H1B interim final rule that came out yesterday. I'm going to read some of this, so if I'm looking off camera, I apologize. But effective as of October 8th, the DHS is estimating that $17,963,871 in annual cost to petitioners to submit contractual documents, work orders, or similar evidence required by this new rule to be established as an employer-employee relationship and qualifying employment. While the maximum validity of the specialty occupation worker is currently 3 years, the interim final rule will limit the maximum validity period to 1 year for workers placed on third-party work sites. DHS will estimate a total revenue starting in fiscal year 2022 of 376,000 plus that's fiscal year 2021, 2022, 2023, 502 million. $330,000 and 510. So $502,330,000 by fiscal year 2023. This is just a total of estimated costs for petitioners. And then that would continue that number 500 million estimated through fiscal year 2027. And that is for petitioners that would be filing the I-129H form requesting H-1B employment for workers at third-party work sites. Under this new rule, the petitioner will have the burden of demonstrating that there is a direct relationship between the required degree and a specific specialty. A requirement of general engineering degree for a software developer position would not satisfy the specialty occupation requirement. In this instance, the petitioner would not satisfactorily demonstrate how a required general engineering degree provides a body of highly specialized knowledge that is directly related to the duties and responsibilities of a software developer position. Wow. So it sounds like computer science, software engineering, these are going to be the degrees that are now going to be required for software developers, for software engineers. For those positions, it sounds like that's going to be the mandatory requirement in terms of the degree. The petitioner will have to establish that the bachelor's degree in a specific specialty or its equivalent is a minimum requirement for entry. So, again, we're getting back to the minimum requirements and the relationship between the specialty occupation and the specific degree. DHS will define work site similar to the DOL definition of a place of employment. DHS will define third-party worksite as a worksite other than the beneficiary's residence in the United States that is not owned or leased and not operated by the petitioner. Yesterday, I alluded to the death of the third party on Twitter. Mark this date. I mean, when you continue to read this language from this interim final rule that's available for public access, you see the continuation, of the messaging here, looking to, significantly increase revenue streams based on third-party placements, limiting the visa extension to 1 year if you're working on a third-party site. So the curiosity becomes, how deep does this go? Is this just for the middlemen? Is this for the integrators? It really is interesting to see how this is going to play out based on this language. It's very restricting. While DHS recognizes that the third-party arrangements may generally be part of a legitimate business model, this business model presents more challenges in the context of the H1B program and USCIS's ability to better ensure eligibility and compliance. According to DHS, this will set a 1-year maximum validity period for all H1B petitions in which the beneficiary will be working at a third-party site. And then the last thing is on the inspections, and this is what we've been talking about for the better part of 3 months now. USCIS will conduct inspections, evaluations, verification, and compliance reviews to ensure that an alien is eligible for the benefits sought and that all laws have been complied with before and after approvals of such benefits. These inspections and other compliance reviews may be conducted telephonically or electronically, as well as through physical on-site inspections, on-site visits. So again, we see, more really power that's going to be given here to the Department of Homeland Security, the USCIS, and even ICE, to conduct these site visits. Not saying that that's a bad thing. I mean, I think a lot of you that follow me out there, find yourself as direct permanent employers working on an H. This isn't really applicable to you, but there is a possibility that a lot of you are working under this arrangement, and now you're really worried about what's next, right? We've seen this pattern of behavior, though, for this entire term. If you go back to 2017, that's when we really began to see the beginning of the 1 and 2 year extensions. Specifically when we're talking about this third party in client sort of placement, right? And where do we see these type of placements? Well, we see them in the corp-to-corp relationships through staffing firms. We see them through integrators, American and Indian, and we see them, in some cases even direct, right? But still, the point is that this has been one of the primary ways that large enterprise organizations have filled these very hard to find, very unique niche skill. You see the reference to the software developer, to the software engineer, and its relationship to the degree. This tells me that if you have a degree in electronics and you're trying to get a software engineering position, electronic engineering, you may not be approved. I think what this tells me is that we have to have a computer science degree. We need to have a bachelor's of engineering and software, specifically if we're looking at software engineering, software developer, application programmers, those type of roles. I think it's the degree now, based on this language, is going to be part of the significance in the specialty occupation definition. It removes some language common and normally, so it really just further strengthens the ability of the certifying officer processing the case to go through and decline if there isn't that parallel. So definitely degree is going to be a big player in this. Very interesting to see, how this move will play out. So wanted to shift, because we'll talk more about this, the interim final rule, throughout. I'll include the link to the public access and the description once the stream finishes up. But I wanted to shift gears here briefly to the October visa bulletin that's really dominated the conversation over the last 10 days, really until this announcement came out yesterday. And what's interesting to me is we really go back and look at the dominoes that led up to the Visa Bulletin, and a lot of the rumors that were circulating and everything around that really got us to when the Visa Bulletin was announced and the ripple effect that it created. Um, it was really interesting to me, and I have to question, why did EB3 jump the way it did? And I haven't had anyone or read anywhere where there's a really viable explanation. Maybe I've missed it. If you have read something that gives you a viable explanation on it, share it with me. I'd love to read it and understand it. Um, but the filing dates jumping the way they did for EB3, and then that information I continue to go back to that was at the bottom of the bulletin, where it discusses rapid forward movement over the next couple of months. And so when I see something that really is a head scratcher, why does the EB3 filing date jump the way it did? And really, the predecessor to that was the discussion around the surplus of family based preference green cards. And what would that rollover, spillover, however you want to refer to it, what would that look like? And we talked about, potentially doubling the 7% gap. Um, but I don't know. I mean, I think when you look at why did EB3 move the way it did, and why has it created kind of the hysteria that it has? Because that's really what it has done. It's created a hysteria. For those that were in EB3 and your date came current, awesome. But what it's done is created a lot of questions for those of you that earned EB2 certification, which, by the way, is more difficult to obtain, is scrutinized and reviewed in a more strengthened manner. Okay. Um, the EB2 designation is not easy to get. While there are more EB2s out there, it is the more difficult to obtain preference. And so I've had a lot of conversations with a lot of you over the last couple of weeks where we've talked about you worked to get to EB2. Your credentials and the job requirement were EB2. Why downgrade other than, hey, it would make your date current? If you're with the same employer and you downgrade, does that give them the ability to downgrade your prevailing wage? I don't know. I was told that it could be even possible for you to hold I-140s and EB2 and EB3. I would have to question what that would look like at the adjustment status and what the intent is, and were those requirements in EB2 truly the requirements, right? And so if your case is pretty straightforward, you're with the same employer, you downgrade to EB3 from EB2, and nothing really changes, I think that your risk is minimal. But those of you who have multiple I-140s with different employers, um, I think you need to really think long and hard about that, what it looks like for you. If your situation personally maybe is dictating you to take that risk, then I understand that. But for me, and this is a lot easier for me to say here on this side, right? Which is I would wait. I would wait to see what November looks like. But this interim final rule that came out yesterday, has a lot of folks freaked out. The bulletin that came out, again, really 2 weeks? Thursday would be 2 weeks, has a lot of people freaked out, right? It just does. It's just the fact. Okay. But the question becomes why? Well, it goes back to Senate Bill S386 remaining blocked, right? And the fact that there's some lost hope that, you know, realistically, the odds of S386, passing in the Senate, as I've covered, don't look very promising. The op-ed piece that Senator Scott put in the Miami Herald pretty much said as much, right? So we're talking about a political favor and an agenda, and we've seen these series of events now. I mean, we're 27 days away from the election, and here the Trump administration, with now over 400 executive actions on immigration, is continuing to go out leading into this election with a lot of activity towards immigration. So the question becomes, why announce this interim final rule 4 weeks ahead of the election. And it comes back to me, feels like political pandering, really looking at the extremes, those that are very anti H1B, those that are on the extreme side of the America First, and um, where they stand on it. But again, it's just very interesting to see how this should be a congressional issue, right? This order being put into place, I have to think is there are probably immigration attorneys right now that are preparing the litigation. I would think so. If it's not filed by tomorrow or Friday at the latest, I would be very surprised. But again, back to the October visa bulletin, and a lot of you that have been thinking about what do you do, and you have to do what's best for you and follow what your instinct. My instinct tells me that something here doesn't sound right, doesn't smell right, doesn't feel right. Could dates retrogress in November? Sure, absolutely. There's a very high possibility that that's the case. But I guess we'll have to take a wait and see approach. Those of you that are on the fence, I feel sorry for you in terms of making this decision. I know it's not an easy one. So the last little update that I wanted to give on Senate Bill S386, which I think is pretty interesting, of course, is that the Senate is not going to return back into session until October 19th. And of course, as we said, election is November 3rd, so very little time to get anything done. Of course, when you're talking about unanimous consent, right, and one person's blocking it, it's one person's vote that's holding it up. So there could be a possibility of bipartisanship. But again, just based on what I just said, and you going back to the op-ed piece on the Miami Herald, I don't foresee that Senator Scott will unblock it. He's willing to take the assault that's happening on social media, the calls to his office. You guys keep going, but he's willing to bear that burden to hold this block. So what does that say, right? They're out of session until the 19th. And you look at the HEROES Act 2 that seems to be, kind of front and center of what they would be expected to discuss and what would be on the Senate floor. I would imagine that the stimulus bill, the HEROES Act 2, is going to take precedent. Which a lot of you were talking about the HEROES Act 2 yesterday. We looked at it, the House Bill 6800, where there is some language that restricts the family-based preference spillover for 2021 and 2022. But President Trump has come out and said that he's not going to do anything that is not just stimulus, right? I think I read that. I think there's been a lot of activity on it today. I haven't really read up on it today. I apologize. I'm just going off of what I saw last night. So, and then the last thing on Senate Bill, S386, and that's, the sponsor, Senator Mike Lee from Utah, tested positive for COVID-19. And that was part of, the Amy Coney Barrett, nominee for the Supreme Court of the United States. And very interesting, kind of parallel there that, Senator Lee, who is the champion of S386, is one of the ones that is in quarantine, at least for the time being. So that's what I have on the interim final H1B interim final rule, the October visa bulletin, and a quick update on Senate Bill S386. Of course, if you have any questions or comments for me here on YouTube, I'd like to ask you just post them in the comments. I'll get to them after I get to the Twitter Q&A. If you haven't already, I want to ask you to please like this video. It helps get the channel out there. I saw we were almost 20 live viewers. Would love to get above that today if at all possible. So those of you that are joining me, just want to say thank you so much. Really appreciate that. So with that being said, let's get on to the Twitter Q&A. So at EVGuy7, at the H1B guy, so you haven't talked about time-bound GC. Would you consider to share your thoughts in tomorrow's video? So time-bound GC, or just any reference to time-bound visas, is where visas are actually restricted based on a specific amount of time, and there's no extension. A lot of it centers around F1 and students, particularly staying past their maximum stay. Um, and I think a lot of what I've read about just the, kind of a time-bound green card would be that, you would be issued 3 or 6 years, and that would be it. They're not extendable. You'd have to have a period of time where you're outside of the country, at least for, I believe, a year or more is what it looks like. So yeah, I mean, there was, I believe, some rumblings on this back in June that the Trump administration maybe was potentially moving closer to a time-bound immigration type system, but we haven't seen much on that since. So at Abhishek_22222, hi, I have an approved EB2 NIW. Do I need to worry about the new wage levels? Go for my next H1B extension. Thanks for doing this. And so, for those of you not familiar with what EB2 NIW is, that's a national interest waiver. It means that Abhishek's proposed work is substantial in merit and national importance, that he's well positioned to advance in the proposed work, and that when balancing all factors, it would be in the national interest of the U.S. to grant you a waiver of the normal job and labor certification requirements. So, an EB2 national interest waiver, one of the stronger categories for EB2 that you'll see, it's actually a completely different I-140 than the normal EB2 I-140 that we see. So I'm going to answer this question with the next one that I'm going to click on, Abhishek. So just hang with me here because these are related. So at Kumar25, Pavan asks, can you please share some new details on the DOL age rule and the updated percentiles? And so what we're referring to here is the job skill level, and they are 1, 2, 3, 4, and 5. And these are where we get the prevailing wage determinations based on the MSA. The MSA meaning the geographic area where you physically work. And as we talked about the work site earlier, the third-party work site, the definite place of employment, right? For work site, third-party work site is working at somewhere other than your employer's place of employment. Okay, and so really quickly, the current skill level 1 is 17%. The increase is 45%, the new percentile. So you see a pretty significant jump for entry level. I know a lot of you guys out there that follow and watch would feel the same way, that you're okay with a significant compensation increase for that level 1. Right? The level 2, 34%, jumping up to 62%, right? So that's about a 28% increase. Both were, it looks like across the board, that's the number, right? So level 2, 34, increasing to 62. Level 3, 50, increasing to 78%. And level 4, 67, increasing to 95%. So 28% percentage points increase on the prevailing wage determinations. So just think about that. If we're talking about a 100K salary, right? The employer, based on this new rule, if you file after October the 8th, okay, would have to be paying you $128,000. All right. So it's a significant increase. We're talking about a 28% wage increase, right? So, Abhishek, to answer your question, is your employer paying you more than 28% above the current prevailing wage? And that's going to be a question that a lot of you are going to need to look into getting answered, because anything, unless you're ready to file today, right? Which I don't know any of you that probably are. ready to file an amendment or extension based on the new ruling that came out yesterday. But you're going to have to calculate your previous prevailing wage determination that's on your LCA and understand, are you being paid more than 28% above that? And if you are, then it won't have an impact on you. Okay, at Halak __ meta. Hi, could you please cover when H4 premium processing is expected to start? Well, to predict when USCIS is going to open and close premium processing and have to look into a crystal ball, I've not really ever had any rhyme or reason as to when they open it and when they close it. I would imagine if they are looking to collect the fees that they need to collect, then they would consider a resumption of it. But I've been reading some horror stories out there about EADs that have been in process for H4 EAD specifically 6 months or longer. The thing about the H4 EAD is got to have that card in hand to continue employment, which it is a challenge. It's unfortunate that they're taking that long to adjudicate these H4 EAD cases. Premium processing would be nice, but I don't know if they have the human capital, the bandwidth to process under premium processing and fulfill the guarantees. So let's see. At EV Guy 7, 1, increasing the wages does not really impact leading American business, doesn't it? And then let's see, 2, U.S. graduates, are they the obvious winner here? And then 3, would American businesses really outsource entry-level jobs? Yeah, I mean, I think that is, several of the questions that are being asked based on this interim final rule. Increasing wages, though, does impact businesses. It impacts those businesses that are holding these H's, right? Specifically, if, again, I'll just use the 100K analogy. Let's say it's a, software engineer of a skill level 3, and they're paying that individual 100K. We're talking about a 28% increase depending on the prevailing wage. Generally they're probably somewhere, depending on the location, mid to high 90s to low 100K. And if that jumps up 28%, now we're talking about 115, 120K. Employers paying the individual 100, they're going to have to increase that. So yeah, I think it would have an immediate impact on American businesses that hold H's. 2, U.S. graduates, are they the obvious winner? Well, ultimately, it isn't about the graduates being the winner, but it's about the qualification, right? Those that are graduating with bachelor's degrees and bachelor's of arts degrees, right, aren't getting software engineer positions. So the question is how do we train those? And we saw that with the H1 workforce program grant, that they're looking to train and upskill those that are either underemployed or unemployed. And would American businesses really outsource entry-level jobs? Yes. Absolutely. If they can get it cheaper and the same level of quality, they would do it in a heartbeat. They would not think twice about it. And that's the worst case scenario. We've talked about, you've heard me talk about it a lot, outsourcing being really the big elephant in the room when we talk about H1B visas. If we don't continue the H1B pipeline as it relates to high tech, those jobs will go other areas, Canada, Mexico, nearshore, for example, and then we start talking about offshore. So yeah, I mean, I think it's a very high possibility. Let's see, here we go. So Palak _ meta, hey, hello, if you can please cover downgrade from EB2 to EB3 with EB2 approved from employer A, priority date of 2013, now in perm process with employer B. Once perm gets approved, is it okay to downgrade to EB3 for I-140 and I-485 concurrently with employer B? Yes, you could do that, right? It sounds like your employment-based EB2, I-140 with the current employer, not the previous employer, but with the current employer is still pending. once that's approved, you could downgrade your I-140 to EB3 and file the I-485 concurrently. Yes, that is a possibility. As I've talked about, though, you're not with the original employer that sponsored, your perm labor and your employment based two category, the original I-140 with that priority date of 2013. Um, so the risk for you may not be that significant, but when I have been advising folks that have this situation, I have been advising to wait till the November bulletin. If you don't want to do that, I understand. But that's just been my advice so far, is to wait till the bulletin. Okay. Hope that helps. And then let's see, last question on Twitter. Let's see. At Indian_Jones_1 dates will retrogress and stay in 2010 for India forever. This HEROES Act change for spillover is specifically for fiscal year 2021. USCIS is expecting to add 120 more spilled GC on top of the 140K limit this year. That will change the day this bill is signed, correct? At H1B Guy? That's the way I interpreted it. And he's referring to the HEROES Act, as we said, House Bill 6800. There is some language that it actually refers to 2021 and 2022. The way I interpret it is that spillover would not be allocated for employment-based preferences. That's the way I read it. I'm not an attorney, nor am I a paralegal. So if your attorney or paralegal has read it and advised you differently, leave me a comment, shoot me a message. I'd love to hear what they said to you about that. But that was my interpretation of it. As I mentioned earlier, it sounds like the good news is that President Trump isn't going to allow any of this additional language that's in the HEROES Act 2 that isn't specific to stimulus to go through. So we'll see if that changes over the next couple of days, but that's the way I have been interpreting it over the last 24 hours. All right, so we're going to get to YouTube questions. If you have any more questions or comments for me, I have not checked Twitter, but post them here in the YouTube chat, and I will get to them now. If you haven't already, I'd like to ask you to please like this live stream. It helps with the YouTube algorithm, as you hear everyone talk about. Just really excited for all of my new subscribers and everyone who's taken the time to join me today. Just really appreciate it. So close to getting to that 300 mark. Looking forward to flying right past that, continuing to produce more content like this for you guys. I'm going to continue to do these weekly live streams, or at least every other week for the H1B Guy Live, unedited and unscripted during the day. So just wanted to say thank you. Prakash Ragapudi on YouTube asks, "Hi, H1B Guy. Thanks a lot for the help in the H1B community. Are you going to be a part of the suit that Greg Siskin is talking about?" Fortunately, I am not. As many of you know, and those who have followed this channel for any amount of time know that I launched this platform and my consulting services and my website, the h1bguy.com, just a little over 90 days ago. And, the growth and the feedback and the responses from all of you guys and the daily messages that I get, the questions and the words of encouragement, just so appreciative, so humbling. I had no idea that people would enjoy hearing me ramble and talk about employment-based immigration preferences. But fortunately, the news cycle over the past, really going back to June, and if we're being honest, we go all the way back to March, right? And the initial big presidential proclamation, the original travel ban, right? It's just given me a platform, and I love to help people. I love to advise, and I love to help educate. There are so many confusing aspects to immigration, to the H1B, to the L1, to the H4 EAD, and just the overall the EADs in general, our OPTs, our OPT STEM. So I hope that this channel and its very little small corner of YouTube, is actually helping a community. And so really appreciate your comment, Prakash. Just means a lot. Thank you for taking the time to watch and subscribe and follow and comment here today. Okay. Prakash Vishnupatla asks impacts to existing EB2. I mean, I think this is the question of the month, right? Because a lot of you are sitting back trying to figure out if I haven't done it already, now I'm at October 7th, am I behind in line, right? And I've advised a lot of you who are itching to do something to just go ahead and get your medical exam booked, right? Because if your dates do rapidly forward move like it's being predicted, then you're ahead of the game there. But if you want to spend the money or your employer is willing to spend the money and you want to take the risk to take the downgrade and do that to EB3, then you need to do that very quickly. Today's Wednesday. You need to make that happen over the next couple of days, or you're going to just be behind, right? That's just the fact. So what are the impacts going to be to EB2? I mean, I think that's the question, right? Could we see a jump to 15, 16 in EB2? A lot of folks that I have talked to feel like 14 would be the absolute max. So that means December 2014, November 2014, October 2014. A lot of people that I've been talking to seem to feel that that would be the max that we'd see for rapid forward movement in EB2. I don't know, Prakash. What do you think? Do you have any take on that? Um, drop me a comment. Let me know. Okay, Shirag Sohalia, my H1B application is approved. Will these rules be applicable to me? I guess the question is if you're currently in the US and you already have an H1B approved, you should be fine. As of October 1st, if you were working in the US under a different status and were awarded an H1B for fiscal year 2021, your status automatically changes. Okay. Um, but if you're outside of the US and you already have the approval, I think the big thing is going to be getting the stamp, right? Getting the consulate appointment if you haven't already, and being able to get the entry approval, specifically if you're on a new H1B. But again, if you have an offer letter, you've got a letter of employment, and you're currently outside of the US, I don't foresee, if you already have an approval, having any issues. I think you should be okay. Hi, regarding EB2 NIW, I thought the NIW petition waived the prevailing wage and labor certification requirements, so these new rules should not affect those with NIW petitions, right? And so, yeah, I mean, as I mentioned earlier, the NIW is a different I-140 altogether. Um, I thought your question was asking about your extension. I'm assuming that you are applying for your H1B extension based on your previously approved I-140 and NIW. I don't that you should have any issues um, in the sense of the prevailing wage determination for your adjustment of status, if that's what you're asking. Um, if you're talking about your H1B, it's still, I believe it still goes back to the LCA though. Um, but I could be wrong on that. There still has to be a prevailing wage determination that's listed on the LCA, even if you are an NIW. But I'm not sure. To be completely honest with you, I'd have to do a little bit more research. DM me if you want to connect with me, Abhishek, on it, and I can help you look into that. Absolutely. Appreciate the follow up, by the way. Future extensions, do these rules play increased wages, etc.? Prakash Vishnupatla again. Yeah, I would think so. I mean, it says October 8th, so that's tomorrow. It sounds like they would be effective immediately. based on the way the rule reads. There is a news release that's out on the Department of Homeland Security site, which is pretty brief. Um, and it talks about, it says this rule will combat the use of H-1B workers to serve as low-cost replacements for otherwise qualified American workers. This IFR will be effective 60 days after its publication in the Federal Register. United States Citizenship and Immigration Services announced that they are foregoing the regular notice and comment period to immediately ensure that employing H-1B workers will not worsen the economic crisis caused by COVID-19 and adversely affect wages and working conditions of similarly employed U.S. workers. This pandemic's economic impact is an obvious and compelling fact that justifies good cause to issue this IFR. So, yeah, effective immediately, right? It sounds like, everything that we've read says tomorrow. And so will be very interesting to see how all of this plays out and if it's challenged in the courts, which, based on the track record of the recent lawsuit cycle that's been occurring over the last year, I would believe wholeheartedly that we'll see some sort of litigation, in regards to this IFR. So I had one more from Indian_Jones on Twitter that I wanted to cover. Do I think that politicians from any side care for Indians at all? They're trying to take away what is working out for us by existing laws. That's I think that's a question a lot of Indian nationals that are working here in the U.S. under a non-immigrant visa are currently asking themselves. You have no vote, right? So your power is simply in numbers and in voice. And if you look at the Biden plan, as I've covered, it really isn't favorable to the H-1B. There isn't a lot of reform. What I think you would see under the Biden plan, if Biden were to be elected, which, as I've been quoting this week from the website 538, predicted and projected to win currently based on today. I think you would see some pretty rapid and instant, talking about in January, right, into January, early February, executive actions that would override, several of the 400 plus that President Trump has written. So yeah, I think you would see that, and unfortunately, the cycle has to be broken in order for it to change, right? And the one thing about Senate Bill 386 that I've been a big proponent of is the 50-50 rule. And it ends a lot of the blanket-based H1s, right? And a lot of you and I have talked about this, which is the country cap percentage, 7% for employment-based preferences for green cards, and yet there's no cap for H1s. So if we are truly looking to hire the best and brightest under an H1, does that mean that we either, one, add country caps to the H1, or that we remove country caps for the employment-based preference altogether? And if we did that, then we would need to look at a merit-based type system. So I don't know. I mean, I don't know. What do you guys think? I mean, I think the question is, what's next for the H-1B? I've, pie in the sky, the H-1B EAD for those that have an approved I-140 who have worked in the U.S. for more than 6 years. I've talked about the H-1B EAD under a merit-based system, where there was 10 categories for points that would be awarded. So, I don't know what the future of the H1B looks like. I know that there are a lot of the America First folks out there that are very anti-H1B, very vocal about the H1B. You hear a lot about the cheap labor debate, the replacement of American and U.S. workers debate. You hear a lot about that. But what the other side that talks about the cheap labor, what they don't understand is that there is a skills gap. And we saw the administration admit that when they came out with the H1B1 workforce program grant. They're admitting there's a skills gap. And so why I'm a proponent of the H1B is because it helps to eliminate that skills gap. I've been a proponent of the third party placement. I'm okay with one layer, right? Meaning, a corporation holds an H1, they are a technology based company, and then they work through some sort of other vendor, whether that is a staffing firm or an MSP, managed services provider, for these large enterprises. Those jobs aren't replacing American workers. They just aren't. And so that's where the gap is. Okay. If we want to talk about, um, strengthening the definition of the specialty occupation as this interim final rule does, we want to talk about making it more difficult on the third party worksite consultant with year increments, right? So what that does is folks aren't going to want to be on a year to year basis, right? So that's going to make it less attractive to them. When you talk about the scrutiny around the degree and what that looks like, right? So all of these things are very interesting plays. I'm really curious to see how they're going to hold up, specifically if a lawsuit comes through. But for the time being, this is what it is. It definitely, if you look at the length of the detail of the release on the Federal Register, it has "he who shall not be named on this channel's" hands written all over it. And I'll leave that to you guys to determine who that is. And, where his role in all of this is just, it's his hands are all over the last few months and very evident based on the messaging, based on the vocabulary, based on the context. Well, if we don't have any other questions, I don't see any other in the YouTube chat. Let me check. Okay. So that looks like it's it for the Q&A for today here on YouTube and Twitter. I just wanted to remind everyone, for more employment-based immigration benefits news, advice, opinions, please check out the H1BGuy.com. If you haven't already, I want to ask you to like this video. I'm assuming most of you are subscribed to the H1B Guy channel here on YouTube, but if you're watching for the first time, I'm going to ask you to please subscribe to the H1B Guy channel here on YouTube. I have another question come in. Oh, good to hear from you again. Neon Adel 123. How are Democrats different from Republicans? How much time do we have? But when it comes to immigration, I think you'll see a lot more America First as it relates to jobs based on the current climate from the Republicans. From the Democratic side, when we're talking about immigration, and I'm going to try to tiptoe around this, they definitely are much more in favor of the DACA, right? That's they prefer that as much more in terms of their immigration platform than they do when we start talking about the non-immigrant and the H1B, the temporary foreign worker. So definitely different, but where are they the same? Well, it's all about the money. It just is. As you can see, we started off this live stream today talking about the millions that is expected to be earned, through this change and the 1 year extensions for H1s working on third client sites. So how are they different? Well, they have a lot of different points of view. They just do when it comes to immigration and what legal immigration should look like, but they're the same when it comes down to the money. So thanks for the question. Appreciate you taking the time to jump in and join in the stream again today. Really appreciate that. I did want to mention, so this is breaking news for those of you that are still on with me today. Next Wednesday night, I am just so excited to bring you another round of the H1B Guy Live Stamp It Out Q&A 3, this time with my very good friend at Wolf_Dog on Twitter. If you haven't, I'd like to ask you to go ahead and follow him out there, but he's going to be joining me next Wednesday, 8 p.m. Eastern, here on the H1B Guy YouTube channel. If you have any questions that you'd like us to cover, I'd love to ask you to direct message me, send them to me. He and I have a lot of exciting things planned to discuss, so really just looking forward to that. That's next Wednesday at 8 p.m. Eastern. And again, I'll just ask you one more time, if you haven't already, please like this video. Please subscribe to the H1B Guy channel here on YouTube and click the bell for notifications so that you're notified anytime we go live, anytime we post a new video here on the H1B Guy channel. If you've made it this far, I want to just say thank you very much. I really appreciate your time. I appreciate your support. I'm just truly humbled to know that you want to hear me talk about immigration and employment-based preferences. Thank you. The H1B Guy, your global source for all things H1B.